unless there has been an addition, a demolition, a land split, an exemption, and so forth since 2007. So the values were established based on sales prior to 2007.
Okay.
Okay, so these assessments could be high, could be low, but they're all once that time. Now, if you are correct, I'm going to go along with what you're saying is for every assessment, on an average, in the town of Seneca, 42% year mill rate in the town of Seneca School District, would go up. So your tax bill would not change. So I'm not picking on your lot or anyone else's lot. I am assessing all the lots to what they are, based on what they are. And that was established in 2007 when the market, in my opinion, was better and there were less properties for sale along the river. Now, I'm not saying with Riverview, I'm not saying with Valley View, I'm just saying along the river. So, your assessed value, in fact, could be high, it could be low. I'm saying that for established 12. If we lower everything, the mill rate has to go up. The municipality is still collecting the same amount of money at the end of the day, whether your assessments are high or low. Does that make sense at all?
Here's what doesn't make sense. If there's this, when a property appreciates, it's my understanding, and that's what it says in the statutes as I read them and the manuals, that the property, if someone adds something, builds on, makes an addition, improves the property, then the property tax is increased because there's an appreciation in the value of the property for the particular parcel of property. Conversely, it's also my understanding that if there's a fire on the property or something that causes the overall attractiveness to a potential buyer to be reduced, that there's a factoring in the tax for an individual parcel of a depreciation consideration correlative to the depreciated value, so that there isn't any unjust enrichment emanating windfall that's being received by any nominal government entity. Do you understand my position regarding the individual parcel?
I do. Now, I also would like to say that your parcel, along with, I'm sure there's many other parcels along that river that have not been touched for 12 years. And I would be certain that they're grown up, like you said yours was, that probably need to be revalued. But I'm not contracted to do a revaluation yearly on those properties. Now, I will tell you from my standpoint, 12 years is a long time to go without a revaluation. And one needs to be done. I'm not going to beat around the bush. I will say that one needs to be done there, but it's not yet mandated to do that. So, I don't want to get off the subject here, but I will say that if I adjusted your assessment to what your realtor said, then I would have to do that all the way down the river, because it wouldn't be fair if your parcel was identical to somebody else's parcel, and I had you at 40-some thousand and them at 60-some thousand. So that's what happens when we do a revaluation, is we value like lots, like topography.
That's what Randy Robertson informed me. Yeah, he said the problem is that you're 28,500 underneath the assessed value in his understanding of what he could get in an at arm's length transaction with a willing buyer at this juncture.
Right. So have you looked at other assessments?
I'm not familiar. I'm not familiar with assessments. What I did is I called the sheriff, because basically what it comes down to is this: if the sheriff isn't willing to enforce, and he needs an objectively reasonable reliance interest under Illinois versus Krull to enforce any law, you can read that case for yourself. Also, there's numerous other cases: Norton versus Shelby County, McGrath versus Anti-Fascist League, that articulate basically the same idea. But here's what the bottom line is: if he wouldn't be willing to come out and force someone off the property, then there could be like an occupy type thing like there was out in Oregon, if you're familiar with that. We could simply occupy the land until we got the matter resolved if no one would be willing to come out and enforce it. So I contacted him and I asked him, I'm trying to negotiate this if any possible way, because that's my moral obligation to understand it. And this is what he said, well, why don't he suggested trying to get a loan to pay someone to cull the trees. I couldn't get a loan because of my profile, and because also there was really no indemnification, as I understand, in the property for the following reason. If someone puts up money, presuming that they could get a lien on the property to back it, all liens are extinguished by the liens of the government if it's foreclosed. So, because there isn't provision for the return to the deed holder after the sale, you see what I'm saying? The whole property stands to be lost. So because the whole property stands to be lost, that's my understanding. And my other characteristics of a profile, I've kind of lived off the grid for the last 20 years now. I didn't satisfy any of the lenders that I tried to access to get the means to pay someone to cull the trees. So that's why I sent the offer to you or anybody else. If someone offered me right now $60,000 for the property with all the encumbrances, or heading into the next year, since it's alleged now another $1,400, 58.5. If someone offered me that right now to be done with this, I would move it immediately just to be done with this, because I have way too many other things to do. Okay, we're heading up into the Republican primary presidential debates, and the next election, and this window is closing. Okay, so there's all kinds of interventions I'm involved in, and my understanding, I need to keep fighting on that level, because that deters a lot of nominal government criminality and violence. It contributes in a widow's mite's way. It throws more drops in the bucket, and the more drops in the bucket you get, the more the line in the sand moves against the whole United Nations Agenda 21 and full spectrum dominance, which is, if that comes down, 5G towers, and they're getting to robotics, where robots are indistinguishable from human beings, the whole thing is going to be like over, okay, because they're going to have such technological superiority, they can get rid of massive components of the population without ever having to go into underground cities. That's their agenda, as I understand it. Now, here's the situation. My question is, how is it fair to the individual parcel holders if the actual value of all of these properties is $28,000 less than what they're being appraised at? How is that fair to all of the similarly situated property holders?
So in Wisconsin, and they were trying to go this direction, but in Wisconsin, we do not revalue properties at 100% every year. It'd be too expensive.
Gotcha.
There's no way physically possible for us to do that. So I ask people this, and I tell them to not take it the wrong way. So please don't.
I don't. Go ahead.
If your assessment, if you went to the realtor and he said, I could get you $58,000 or $48,000 for this property,
Right.
and it was assessed at $28,000,
Okay.
would you call me up and send all these emails telling me that my assessment is too low and it needs to come up $20,000?
The answer to that question is, if it was a jurisdiction with a constitutional sheriff, such as, well, Milwaukee had a sheriff who did an enormous amount of good, now he's gone, of Glenn Palmer of Daly County, Oregon, and there were no abortions, there was no pornography, there was no corruption of the children in the school system, I would say absolutely, yes, I would, because I would be concerned that the education, my focus is on the children ages 1 to 7 basically, and any people of goodwill in Crawford County. What can I do to empower them, okay? And out of their empowerment will become a rippling effect through the wave of empowerment. I have no interest in holding assets, okay? At this juncture, all holding assets is a target. According to Dr. Edwin Cordero, you can read his material, it costs like $500,000 for someone who can pay to go to the United States Supreme Court with all the preparation through the appellate court record and all these different things to go to the United States Supreme Court. I've tried to file numerous petitions and I've just got the things sent back to me with, rejected. I've been on the phone with clerks there, whatever, but here's what I'm trying to share with you. I absolutely would do that if I understood that the overall effect was that children weren't getting the measure of education, instruction, and resources necessary for them to be empowered. Yes, and I'm willing to do that. I'm willing to do that. Call me. Consider me a resource moving forward. I try to proceed through life in reciprocal empowerment associations and alliances. Okay, that's what I'm always looking to do because that's what I understand my moral obligation is. But yes, I absolutely would, because I would consider that I would be concerned not to get an unjust enrichment emanating windfall, and you could incur culpability for an unjust enrichment emanating windfall in many ways. The example you provide to some extent is substantially different, but that's what the inheritors of the Rothschilds' defraudments of the money supplies, they've inherited a gigantic windfall. Yes, they are absolutely obliged to divest of that unjust enrichment emanating windfall because their claim to it is not legitimate. So yes, thanks for the question, and that's exactly what I would do, and I will do that in the future. And the other thing is this: you can go to the website john21-15protctr.tripod.com, and you're invited to, within marginal utility for you, whatever that constitutes, to file complaints against me, file complaints against any other members in the Institute of St. Michael the Archangel, and we will post those complaints right at the top of the web, or linked to where your complaint is posted and it's accessible at the top of the website, because we are concerned as we proceed forward that we cause no unjustified injury to anyone, and we can incur culpability for causing unjustifiable injury either by excess or by defect. So the answer to that question is I absolutely would do that, and I thank you for the question. And I'm also interested in answering other questions you have in this type of regard, because I'm just trying to get to the bottom of the issue. Based on what you told me today, what I'm probably going to do is I'm going to send the first installment for 2018. I'm going to send it to someone to hold in escrow. And so it's understood that I'm divested economically from any interest, and I don't think there's many people whose phone you're going to get a phone call from someone who's going to be 59 in 2 months who my impression would be you're not going to get any phone calls from anyone who's more highly committed to ensuring that the common good, the public interest, what I call the Catholic cause, because everyone has a soul that lasts after they die, or in eternity if Christ returns before someone dies in a given instance. The point is that's my only concern, and I'm also convinced that many people, the vast majority of people, end up with all kinds of unpleasant surprises on that last day. I don't want to have that happen to me. So that's why and I apologize to anyone and everyone for replicated emails and things that are time consuming and so forth. If Mark Peterson simply would have been willing back in April to answer my questions, to address the issues, I get a confirmation the email is received, but that's it, because he's the representative of the executive branch. I'm now addressing you as the members of the executive branch that will discuss something with me. I'm addressing because I have to mitigate the damages of either the county board president or whatever that is for Crawford County and or his corporation counsel not providing answers to all these questions, because as you understand, digging through all those different statutes, trying to figure out what constitutes the antecedents of the various substantives, and digging through the subordination and coordination, and trying to figure out, are you dealing with individual taxpayer and the lowest government entity, are you dealing with the district and the county, are you dealing with the county and the state or municipality and the state? Reading through those statutes, much of it ends up later you realize that, you know what, this didn't really apply to what my concern is. So I mean, I can read certain the subcomponents. You know, mineral rights. It has nothing to do with mineral rights. It has nothing to do with football stadiums, or it doesn't have. I can see some of the things that I don't waste time reading any of those. But the things that might be relevant, I got to dig through because that's my moral obligation. Because I might be in the wrong. So, any rate, all right, gotcha. Then, well, you know what? I don't have any other questions that you've answered my question. Unless there's something you want to add, I'm just going to pray for a couple hours and go put something. I'm 2 blocks or I'm 2 miles away from there's a 12 o'clock drop at midnight, and I'm going to go do something to whatever constitutes the least difficult alternative to justify under these conditions, and that's what. And then I'll just, whatever happens. So the other thing, go ahead.
I guess basically I want you to know, Robert, that these assessments are not current market value. These assessments are from 2007. And until we do a revaluation, they're not going to reflect current market. So, as far as talking about market value, I just don't know how else to tell you it, to make it clear to you that you are you're not unfairly assessed in comparison to other similar properties in the township of Seneca.
Gotcha, but you have to admit the possibility that it could be that all such properties, similarly situated properties, are being unjustifiably assessed. I thought there had to be a reassessment every 5 years, and I thought it had to be within 10% of market value. That's what my recollection is. I read that in the manual, but that may not be applicable. But also the other thing is this: I think it's
let me comment on that. Yes, the township has to be within 10%, and it is. As a whole. Now, you have one of the issues in town of Seneca is, are you very familiar with the town of Seneca?
Never been there, don't know anything about it.
Okay, so what we have on the west side of the township is a lot of subdivisions and a lot of smaller tracts that sell for more money because of the location, which it's in close proximity to the river. And then you have the east part of the township that is down in the valley, lowland, swampy, farmland, not very saleable. So when you have sales down there, they may be a little higher than what I'm assessing. And when you have sales on the west side, they may be a little lower than my assessed value. And so as a township as a whole, they offset each other because you have sales that are selling for higher than my assessment, and you have sales that are selling, or properties that are selling for lower than my assessment. So when you take an average throughout the township, it says that we're in compliance. So we don't have to do a revaluation. So that's one of the issues in Seneca is that there are properties that are overassessed, there are properties that are underassessed, and until we do a revaluation to get all those things squared away, they're going to stay the way they are.
Gotcha. So that who makes the decision? Because correct me if I'm wrong. There's a reference to 5 years in that manual, and there's also a reference to 10% of market value. So for the individual parcel, isn't it necessary that not be more than 5 years between the times of the viewing and the consideration of the value?
Once the township falls out of compliance, you have 5 years to get it back into compliance, or the Department of Revenue will do it for you.
Okay, once the township falls out of compliance, you have 5 years to get it back in or the Department of Revenue of the state of Wisconsin will do it for you, right?
Yes.
Okay, gotcha. So in other words, there is no obligation to the individual property holder to have the property reviewed and assessed every 5 years.
No, because as I stated before, if I would come out to your property and I would say, you know what, Robert, I agree with you. It's only worth $48,000, not 66.
Okay.
I would have to go along that entire river and find every property that's like yours and revalue it. And
Okay.
I would also need to revalue a lot of the other properties because I don't feel that they are assessed correctly, and that would constitute a revaluation.
Okay, and then the other thing I was going to say, so there isn't, so the 5 years is only for the aggregate. The 5 years, there's no obligation for the reviewing of the property of the individual parcel every 5 years. It's just for the aggregate, right?
Correct.
Okay. That's where I got confused in the manual. And then the other issue is, does it have to be for the individual parcel? Does the parcel have to be within 10% of what it actually would sell for? Or does that have to be within 10% of anything, or is there no ceiling on what could be assessed for an individual piece of property?
No, it's on a township basis. Now, there are situations where, let's just say like a house, 15 years goes by and that house is in the middle of the woods and the old lady that lived there died and nobody's done anything with the house and the house is completely falling apart. Then in that case, I would revalue the house because it's shown that basically it's falling apart. Now, that's a one instance case. Your lot is maybe growing up, but it's not falling apart. There's other lots along that river that are like yours that are probably overassessed. That need to be revalued. It needs to be revalued. I can't stress it enough, and I've tried to, but when the town sees that it's at 95%, they don't want to do a revaluation, and not enough people complain about it, and so they just stay the way it is.
Gotcha. All right, because I'm looking at the whole. If like my position from the deed holder would be that if all the values are overassessed, then they should all be corrected. But here's the upshot of the whole thing. If someone is interested in buying that property, anyone is interested in buying the property for what I said, like $60,000, or maybe now for the next year, $58,500, I'll just take it, and that I'm already divested of it anyway because I'm involved in the Institute of St. Michael the Archangel and everything we're trying to do. There's no point in me having resources because the arguments I make, the claims that I make, I'm just a target for totally unjustified sanctions. I'm banned from many court buildings because of the arguments I make, the questions I ask. I've never done anything that's rude, arrogant. I've never raised my voice, but I am persona summa non grata with many nominal government entities because of my insistence of these are the terms and conditions I understand of the component of the moral law with which the Constitution of the State of Illinois, the United States of America, is compatible. This is my obligation, and this is my question for the judge, for the prosecutor, for whomever it is. These are my compatibility demonstration demands, and these are my questions. And just in asking those questions, the compatibility demonstration demands, I've been falsely arrested numerous times, and it's really been an ordeal. It's an uphill struggle. But at any rate, okay, I appreciate I'm less ignorant than before I started. So, to your knowledge, like I say, if someone, the other thing is this, if someone called me right now, or someone called me between now and the next 90 days and said they'll purchase the property at the price that I just, with its encumbrances at the price, I would then have no complaint. You see what I'm saying? Because then the property would have actually sold without my having to invest more sweat equity and more resources into it for something that's close enough to $69,700 that I'd be done with it. You see what I'm saying? That too would have left me off the hook. Does that make sense? If someone, in other words, I wouldn't want to get a windfall, okay? Because, like I say, I'm concerned to not have any windfalls. I'm concerned to proceed through life as much as possible without incurring culpability in any sin. But there's, we're limited, fallen, contingent creatures, and we have to deal with the situation that we encounter. So, but anyway, I'm less ignorant than before we started. What I'm going to do is, since you're not sure about the legal significance, that's not going to make any difference now in the next 6 hours. But I do appreciate you're trying to explain to me the aggregate versus the individual, because I'm less ignorant, and between now and 11 o'clock tonight, I'll figure out in the balance what I have to do. But other than that, I'm actually in a library. Yeah, I've got. Okay, I'm almost done. Okay, I'm in a library here, and I got to finish this conversation. So, at any rate, gotcha. So I think I understand. I'm going to recapitulate all this. I don't, in the balance, see that it's justified for me to remit the whole amount. I'll probably remit the whole amount into escrow, or 58% into escrow, and then I think I've done enough, in my understanding, to protect the claims against any invocation of any non-compliance with prerequisites in order to get a adjudication in the court system according to the promulgated rules. So if there's anything else that you want to add, you're welcome to add, or you're welcome to call 708-317-8812, email me, go to the website. Like I say, there's complaint forms on there, and because the bottom line out of all this, one of the things I try to get at the end of a dispute or during the dispute is I'm just simply trying to get the malum prohibitum components of the Constitution declared to be unconstitutional as applied to the activity of Robert J. Moore until the protection of the purchasing power of the currency is restored, the gigantic, ill-begotten, unjust enrichment emanating windfall has been divested, and the core temporal problem has been fixed. So if there's anything in my activity that's not compatible with that, please bring that to my attention so maybe I can get your endorsement later on down the line. The other thing is I offer the same type of consideration reciprocally. If you're getting bullied by the government, call the Institute of St. Michael the Archangel. If you got someone else that you know, that we're available, and that's what our role is as we see it at this juncture. But at any rate, go ahead. Anything else you can finish, and either that or I got to move on to the next task.
Yeah, that's I don't have anything else. I just hopefully you understood a little bit of what I tried to say, and we'll just go from there.
I gotcha. Well, and I'm going to send you a copy of the recording and send you a copy of everything else, and so we can get a stipulated, so we're all in the same, we're not talking past one another, hopefully, and we're trying to negotiate this in a way that is acceptable. So you got my information. I'll leave it at that. I got to move on to the next battle. Thanks a lot. Bye-bye.